The prosecutor goes death for Bryan Kohberger. The Department of Justice says nothing to see here in regards to that guy named Jeff. The federal judge denies the prosecution's motion to seal the witnesses against the former president, an example of how not to behave in court. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is CrimeTalk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that little bell, and remember you can listen to us anytime on any of your favorite podcasting apps. Now, please join us tonight for our live program. We will be here this evening on YouTube, Facebook, and Rumble. You can catch us at 6 p.m. Mountain Time, and it's going to be good. And guess what? Tonight, we're going to give you a special treat. You can call in to either ask questions or maybe just state your point about what we're talking about. We will be discussing Bryan Kohberger along with any other matters that, well, all the true crime aficionados want to talk about. All right, let's go ahead and open the docket for June 27th, 2023. All right, as you probably heard, Bryan Kohberger, the man charged with killing of the 4 college students in Idaho, guess what? The prosecutor has decided to go death. And in his filing, he says, at this point in time and based upon the information known to the state to date, the following statutory aggravating circumstances pursuant to the Idaho Code appear to exist in the case as to the crimes of murder in the first degree, as charged in counts 2, 3, 4, and 5 of the indictment. The Idaho Code states that the murder was committed by the defendant, also committed another murder, and or the Idaho Code also says that the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. And also the Idaho Code states that by the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life, and that the murder was committed perpetuating or attempting to perpetrate arson, rape, robbery, burglary, kidnapping, and mayhem, and the defendant killed, intended to kill, or acted with reckless indifference to human life, and the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, had exhibited propensity to commit murder, which will probably constitute a continuing threat to society. Therefore, the state gives this notice because it has not identified or been provided any mitigating circumstances sufficient to prohibit the trier of fact from considering all penalties authorized by the Idaho legislature, including the possibility of a capital sentence. Consequently, considering all the evidence currently known to the state is compelled to file this notice of intent to seek the death penalty. The state will continue to review any additional information as it is received, and it reserves its statutory right to amend or even withdraw this notice. So there you have it in their own words. What does that mean? Yes, they want to kill Bryan Kohberger if he is convicted. Obviously, he's still entitled to the presumption of innocence, but the case must think that they have a pretty strong case, that they're going to be able to convict him and then ultimately seek the ultimate penalty. Now, the prosecution still had some time. They had another 4 weeks until they actually had to decide this, but they decided early. What could this mean? It could be to say, hey, defense, game on. But why don't you also give us some mitigation? Make me change my mind. Maybe you want to plead guilty in exchange for taking away the death penalty. These are the games that are played in a death penalty type of case. Now, I've told you before, I've done one death penalty case. We were able to convince the prosecution to withdraw the death penalty before they actually decided to go forward with it. And we did something radical. We went and actually did video interviews, and the DA said that was something that they had never seen before. So the question is the prosecution going to ask the defense to say, hey, give me something to change my mind? Or is the defense going to charge forward and say, my guy is innocent? We'll have to wait and see. Now, we do know that the trial will probably not go as planned. That was scheduled to start on October 2nd. So be ready for that delay. And like I said, we'll have to wait and see if there's something that's going to persuade the DA not to go death. Now, we are learning a little bit more about Bryan Kohberger. The guy's had some trouble in the past, which is probably why he's not a police officer, which is why he truly wanted, why he was studying what he was studying. He couldn't be a police officer. But we did learn that he was arrested back in 2014 after stealing one of his sister's iPhones while he was battling his drug addiction. Now, Kohberger was 19 when he was arrested in Pennsylvania, and he was charged with misdemeanor theft after his father, Michael, reported to the police that he had in fact stolen his sister's phone. Michael, the father, told the police his son was warned him not to do anything stupid after he learned he had taken the phone from his sister, and the father also reportedly mentioned Kohberger's addiction to heroin that he was struggling with at the time. He served no jail time for the theft, and there's no public record left of it because as a first-time offender, he could have his record sealed after completing the pretrial diversion program. Apparently, prosecutors are looking into this information, obviously, see if there's any relevance as it relates to the case that he's currently charged with. I can't see a whole lot of relevance. It means somebody made a stupid mistake while they were on drugs. Heck, most of my clients made stupid mistakes while they were on drugs or alcohol or rage. It just depends. But, everybody gets a break the first time as long as nobody's hurt. Obviously, when there's a dead body, the general rule is, somebody's got to go to prison. You got 4 dead bodies, yeah, you're in the death penalty area. All right. So Bryan Kohberger is actually expected to make a court appearance later today. If there's any breaking news, hey, check us out tonight on our live show. And remember, you can also be a part of the Patreon show immediately following that. The hearing today, the judge will hear arguments from both sides regarding several motions, including one filed by Kohberger's team asking that the prosecution to hand over more evidence regarding the DNA allegedly used to try and link him to the crime scene. Now, the defense has said there is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, or vehicle. And their pleadings stated that by December 17th of 2022, lab analysts were aware of 2 additional male DNAs. Now, the defense pleadings stated that by December 17th of 2022, lab analysts were aware of 2 additional males' DNA within the house were located at the scene. The defense team has also stated that a second man's DNA was found inside the home and that the police allegedly found DNA from a third man's DNA on a glove discovered outside the home. And the defense takes a shot at the prosecution, says the defense is unaware of what sort of testing, if any, was conducted on these other samples of DNA. And the filing also states that an objection to the state's motion for a protective order argued the defense team should have access to all of the data and investigative genetic genealogy that led prosecutors to claim that Mr. Kohberger's DNA collected with the buccal swab was a statistical match to the DNA found on a knife sheath discovered at the scene. Now, earlier this month, prosecutors claimed that the DNA found on the knife sheath left at the Idaho murder scene is a statistical match to the cheek swab taken from Bryan Kohberger. Now, the FBI says they use databases in publicly held DNA sites similar to 23andMe, and the prosecutors previously argued that Kohberger had no right to the FBI data uncovered from the methodology that they used. Now, the defense filing says, perhaps, unsurprisingly, Mr. Kohberger does not accept that the defense does not need this information. The state apparently only wants to prevent Mr. Kohberger from seeing how the investigative genetic genealogy profile was created and how many other people the FBI chose to ignore during their investigation. I love the sarcasm in their pleadings. They're probably going to get that information. It'll be subject to a protective order. But I was dealing with this issue just last week. They're saying there's nothing to see here. You don't need to know the methodology of how they were able to do something. It's too scientific. You're too stupid to know it. And we can't release how the magic was done because, it's proprietary and they would lose their advantage of it. Well, guess what? I think we're going to get it all. So when the government says you're not entitled to it, all that does is tell me, now I really want to see it. Next on the docket, the guy named Jeff. That's right, the DOJ, the trusted DOJ, says that guy named Jeff and his death was a suicide, and there was absolutely no outside involvement. That's according to a report that ruled that after years of rampant theories questioning why the notorious, well-known, connected pedophile was able to take his own life while in custody. Now, that guy named Jeff allegedly killed himself in his cell at the Metropolitan Correctional Center in Lower Manhattan in August of 2019 while awaiting trial on the sex trafficking charges. He allegedly hung himself using excess prison linens, which he should have never received. And at the time, that guy named Jeff was charged with recruiting underage girls for his own gratification and entangling them in an international operation where he paid them and in some cases held them against their will. There were obviously rampant rumors, fueled in part by the guy named Jeff's legal team themselves, alleging that his suicide may have been aided by an outside party to cover up other roles in these alleged crimes. Well, the DOJ has been investigating his death, and whatever anyone has said up to this point, yes, there's someone to blame. The 128-page report by the Inspector General finds that staff shortages, inadequate surveillance cameras contributed to the death, but there is no evidence anyone was directly involved. And they quote in the report, while we determined the MCC New York staff engaged in significant misconduct, we did not uncover evidence contradicting the FBI's determination that there was no criminality in connection with how that guy named Jeff died. The Inspector General said in a video statement that also accompanied his report. Hey, I don't know if the guy hung himself or if there was something nefarious going on, but you got to admit it's kind of interesting to think about. And if anyone has or knows where I can get one of those little air fresheners that you put on the mirror of your car that says this air freshener didn't hang himself, just let me know. I'd like to see it. Next on the docket, the judge denies the government's motion to seal in the case involving the former president. So yesterday, the federal judge overseeing former President Donald Trump's prosecution on charges of illegally holding onto sensitive national security documents denied the government's request to keep secret a list of witnesses with whom Mr. Trump has been barred from discussing in relation to his case. Now, the ruling by the judge, Eileen Cannon, in the Southern District of Florida means that some or all of the list of 84 witnesses could at some point become public, offering further details about the shape and scope of the case that special counsel Jack Smith has brought against Mr. Trump. Now, the government's request to keep the names of the witnesses secret does not offer any particularized basis to justifying sealing the list from public view, Judge Cannon wrote in a brief order. It does not explain why partial sealing, redacting, or means other than sealing are unavailable or unsatisfactory, and it does not specify the duration of any proposed seal. While the identities of the witnesses remain unknown, many of them are believed to be aides and advisors close to Mr. Trump, among them several who work or worked with him at Mar-a-Lago, his private club and residence in Florida. Now, as part of the magistrate's order when Mr. Trump first appeared in court, he was barred from discussing the case with any of his co-defendants. Now, Walt Nauta was his personal aide, and now, last week, the prosecution gave Mr. Trump's legal team the witness list, and they asked the judge if they could keep the names under seal. In that request, the prosecutions noted that Mr. Trump's lawyers had not taken a position on the request to seal the list. Then on Monday, a group of news media organizations filed their own motion asking Judge Cannon to make the list public, saying that the case against Mr. Trump was one of the most consequential criminal cases in the nation's history. And they stated that the American public's interest in this matter and the need to monitor its progress every step of the way cannot be overstated, is what the news organizations stated in their filings. Now, in her ruling, Judge Cannon said the petition by the news media was moot, which means it's no longer necessary to rule on that, given that she had denied the government's motion request to seal. Now, it remains unclear from the judge's order if Mr. Smith's office would ultimately post the witness list, perhaps redacted in some way, on a public docket, or if the prosecution would simply be unable to stop Mr. Trump's lawyers from making the list of names public should they choose to do so. In a separate order, the judge asked Trump's legal team to respond by July 6th regarding Mr. Smith's request to delay the start of the trial until December 11th. Judge Cannon also scheduled a hearing for July 14th for the parties to discuss how to handle the significant amount of highly sensitive material involved in this case under a law known as the Classified Information Procedure Act. That hearing will be conducted mostly, if not entirely, under seal. So what does this really mean? Well, guess what? Obviously, the defense is entitled to that witness list, and it'll be known, and the defense shouldn't go out there doing anything reckless where somebody could get hurt. Do I really think that somebody is going to go harm witnesses? No, but people will probably dig into what they have to say and look at items of their credibility. The prosecution should have to put out the witness list. That's just the way it is in every case. Normally, it's filed when there's filing of charges, and only if, for example, somebody is a confidential informant, or you can actually show that somebody's life is in danger, guess what? That witness list becomes public information. That's why you oftentimes see at crime scenes, people don't want to cooperate because they don't want to be listed as a witness, and people think that they are talking. And that's why it's so important in our judicial system, where anybody can say just about anything they want in the court of public opinion, but it's another to be subjected to cross-examination under oath as to whatever statements that you've previously made. I think the judge made the right decision in this particular case. We'll see if the prosecution files a more detailed motion as to why the list should be sealed from the public. Now, one of the things you'll find in federal court is that the judges are sticklers for the criminal procedure rules and for their own local rules. You'd be surprised how many times a pleading in federal court will get kicked out or refuse to be acknowledged because it didn't follow the local rule. It was the wrong font. It was the wrong type size. You name it. You got to follow the rules meticulously in federal court. Now, the prosecutor in this case is probably more used to filing things in D.C., the District of Columbia, where everything's rubber stamped for the government. And now somebody's actually saying, well, did you read my rules and explain why this should be sealed? All right, how not to act in court. Take a look at this guy. He was convicted of murdering an 11-year-old girl and her babysitter back in 1990. Well, did he punch his attorney, or was it just a, accident? Anyway, he was wrestled to the ground in court while they figured it out. Now, Joseph Zeiler was sentenced to death in the slaying of an 11-year-old named Robin Cornell and her babysitter, Lisa Story, who was also, sexually assaulted and suffocated. Now, while in front of the judge, Zeiler asked for the cameras in the room to be taken down before using an expletive and then elbowing his attorney, Kevin Shirley, in the face. Zeiler, who was arrested in 2016, 26 years after the cold case murders, was expected to plead with the judge against the jury's death sentence recommendation. But after the elbow was thrown, the judge asked Shirley if he was okay, the attorney, to which the attorney responded that he has taken harder hits before. The punch came after Zeiler, still in handcuffs, appeared to be quietly trying to deliver a message to his longtime attorney. It seemed like he didn't want our conversation to be picked up by the microphones, so he waved me down and I bent over, and he struck me, the attorney said. After being dragged back in, the man reportedly growled at the judge and those watching, exposing the words "killer" written on his teeth. Despite the shocking message inside his mouth, he refused to have relatives speak on his behalf, claiming that he is innocent. He said, "I have nothing to do with this. I maintain my innocence." The judge, following the recommendation of the jury, denied Zeiler's motion for a new trial and decided not to overturn his conviction. He was sentenced to death by the judge inside the courtroom several hours later. So back in September of 2016, police announced that they had arrested Zeiler, and he had been arrested for the killing after police matched his DNA to traces found at the scene. The semen was found on the bedsheet where Robin was sleeping, and it matched the defendant to a frequency over 1 in 700 billion. So it would be 1 in 700 billion people. It would be his DNA. Pretty big numbers, although they can be manipulated. I get it, but that's pretty strong evidence. Why would his DNA be on there in a toddler's room, in a kid's room? Yeah, just saying. Anyway, Miss Story was looking after Cornell when Zeiler attacked them. Jan Cornell, Robin's mother, who had gone to stay at her boyfriend's home for the night, returned home the next day to find their bodies. The murders were counted among the most famous unsolved crimes and were actually featured on America's Most Wanted back in 2010. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. And finally today, our dumb criminal of the day. Please meet Rhode Island Senator Joshua Miller. He was arrested Friday for allegedly keying a car with a Biden sucks sticker on it. Now, according to the Rhode Island Police Department, Mr. Miller, who's 69, was charged with vandalism, malicious injury to property for using his key to scratch a Nissan Pathfinder parked next to his pickup truck at a local mall. Now, the SUV owner called police Thursday afternoon after he walked back to his vehicle and heard a loud noise, some sort of screeching noise resembling, I don't know, like maybe a car was being keyed. Yeah, it was his car. Now, Miller could be seen holding a key and then quickly walked away towards a vehicle with a re-elect Senator Josh Miller sticker on his bumper. The passenger asked the state lawmaker if he scratched the vehicle, and, well, he denied it. After seeing the bumper sticker, the victim looked up Miller and identified him as the alleged attacker. 2 hours later, Miller returned to his vehicle and was stopped by officers when he tried to leave the parking lot. He denied committing the crime, and the victim was brought to the scene to identify Mr. Miller as the culprit. Now, police were able to review that pesky security footage and corroborated the eyewitness account of the keying of the car. When officers confronted Mr. Miller with this additional information about the crime, Mr. Miller, yes, the state representative, the elected official, admitted to damaging the vehicle. Well, it's good to know that he lied and lied and lied, but ultimately came clean. If only it were that simple in politics, wouldn't it? Shortly thereafter, he was arrested and taken to the Cranston police station and charged, where he was released on a $1,000 personal recognizance bond. His next court date is July 18th. Now, the police put out a statement and said, nobody is above the law, including those that make and enforce the laws. That was Colonel Michael Winquist from the state police. The officers who handled this investigation did so with fairness, integrity, and without preferential treatment. Isn't that nice? Isn't that what the police are supposed to do? Look for the facts, follow the evidence, let the chips fall where they may. No preferential treatment whatsoever. Otherwise, people start to think there's, I don't know, like a two-tier criminal justice system. Just something to think about. All right, thanks for joining us today. Please join us tonight, 6 p.m. Mountain Time, here on YouTube, Facebook, Rumble, all at the same time, and we'll be taking your calls. We look forward to speaking with you. We'll see you tonight.